Insurance. Insurance can be a big part of litigation. You may, for instance, suffer a loss under circumstances where someone else is to blame for it, and you have a negligence or other liability claim against them to make them pay for the loss. Your own insurance may cover the loss so that you don't need to sue the party responsible for it. Yet your insurer may elect to file a lawsuit once the insurer pays for your loss, but that's up to your insurer and not your problem. On the other hand, if you have no insurance coverage of your own or your insurance pays for only part of your loss, you may decide to proceed with your claim against the responsible party. That party, though, may have their own liability insurance to pay you for the loss. Thus, your own insurance or the responsible party's liability insurance may cover your loss, with or without the necessity of a lawsuit. Look around for insurance if you suffer a loss. Insurance may dictate whether you sue and, if so, whom you sue, on what legal claim, and for what loss. Indemnity. Insurance policies indemnify insureds for losses. Indemnity is a fancy word referring to payment, coverage, or reimbursement for loss. A health insurance policy indemnifies or pays for healthcare costs. A vehicle insurance policy indemnifies or pays for vehicle accident repairs and for liability owed to another party due to loss from careless vehicle operation. A homeowner's policy pays for accidental home damage and may include a liability coverage to pay for harms to guests from defects on the premises. Wherever you see an insurance policy, it is generally indemnifying or covering for the risk of a certain kind of loss, either a loss to the insured party or a loss caused by the insured party. Some insurance policies, like a homeowner's policy or commercial general liability policy, cover both kinds of losses, to the insured party and caused by the insured party. Pay attention to insurance coverage relative to your lawsuit, if your lawsuit involves some kind of unintentional accidental loss. Defense. Liability insurance policies generally have a second valuable feature beyond paying for losses. Liability insurance policies also bind the insurer to pay for the cost of defending claims for losses. That obligation means that the insurer will choose, retain, and pay attorneys and court costs to defend the insured against a claim for a covered loss. A liability insurer's defense obligation makes sense. If the insurer is going to pay for the loss, the insurer would also want to choose and pay its own attorney to defend against the claim, and thereby minimize the insurer's loss payment. The insurer wants to retain skilled and experienced defense attorneys to minimize the insurer's payment and maximize its profits. To the insured party, the insurer's obligation to pay the defense attorney and court costs can be just as valuable in some cases as the insurer's obligation to pay for the loss. Defense attorneys and court costs can be expensive. If you face a lawsuit alleging a loss for which you have liability insurance, notify your liability insurer promptly so that your insurer will both pay for the loss and defend the lawsuit demanding that payment. Health. Health insurance may well play a role in your lawsuit if your lawsuit involves any medical expense. While health insurance is not liability insurance, health insurance can play a role in liability lawsuits over personal injuries in which the injured person had insured medical expenses. In that case, the health insurer will pay the injured person's medical expenses, reducing the injured person's damages in the liability lawsuit. Depending on your state's law, the defendant in the liability lawsuit may either get credit for the health insurer's payment, reducing the defendant's damages obligation, or the defendant may have to pay for the medical expense so that the injured person can reimburse the health insurer as the policy would very likely provide. Rely on your attorney to help sort out how these payments work in your state. Just know that your health insurance can affect your recovery in a liability lawsuit for medical expense due to your personal injury. Vehicle. Vehicle insurance will almost surely play a role in your lawsuit if it has anything to do with a vehicle accident. All states mandate that vehicle owners maintain insurance on vehicles operated on the public highways. Vehicle insurance can be both a liability insurance paying for loss you or other insureds under your policy caused to others by negligent operation of an insured vehicle, and to pay for your own vehicle or other covered loss. Motor vehicle insurance laws vary widely from state to state, with several states having no-fault insurance laws that modify the common law of negligence. Vehicle insurance policies also vary widely, with some policies covering vehicle repair, collision coverage, but other policies not covering vehicle repair. Some policies also include special underinsured motorist (UDIM) and uninsured motorist (UM) coverage. Consult a qualified attorney for how the vehicle insurance laws of your state work and to learn your full rights under your specific policy. If you have a motor vehicle accident for which you have insurance coverage, expect it to pay for some or all of your accident losses while also paying for some or all of the losses you cause to others due to your negligent operation of a motor vehicle. Your vehicle insurer may pay not only for the loss you cause, but also for the attorney to defend you. Homeowners. Homeowners insurance may play a role in your lawsuit if it involves an accident or other loss in or around a residence. Homeowners insurance is another form of insurance that can both cover your home loss from fire, flood, wind, or other accidental damage, while also covering your liability to a guest or other person injured by a defect on your land or in your premises. A guest trip and fall over a torn carpet, slip and fall on icy steps, or fall downstairs with a missing handrail that the building code requires could all be liability examples, depending on your state's negligence law. Your homeowner's insurance may even cover your liability to another for defamation or other peculiar claims falling under what homeowners' policies call advertising injury. If you face a liability claim, notify your homeowner's insurance of the claim in case it falls under your policy's coverage. You may end up with both indemnity and defense of the lawsuit against you, sparing you of any out-of-pocket costs. Malpractice. If you face a lawsuit alleging your professional negligence, or if you sue a professional for careless service, malpractice insurance is likely to play a role in your lawsuit. Malpractice insurance is liability insurance covering professionals like physicians, nurses, dentists, lawyers, engineers, and accountants. If the professional causes an injury or loss through the professional's service, the malpractice insurer will both retain a defense attorney and indemnify the loss. The professional may end up paying nothing, not for defense and not for the loss. Insurance policies tend to give the insurer the choice whether to settle the lawsuit, and, if so, for how much, although law requires the insurer to exercise that discretion in good faith. The insured is only along for the ride, but in the case of malpractice insurance, especially in the medical field, a settlement may affect the professional's license or reputation. Some malpractice policies thus give the professional a veto over the settlement decision. Nonetheless, expect a malpractice insurer to call the shots in your lawsuit involving professional performance. Bonds. If your lawsuit involves construction defects and the liability of contractors, you may find that bonding plays a role. In the construction trades and some other fields, bonds take the place of liability insurance. The project owner retaining the contractor will require the contractor to obtain a bond to cover any defect or failure in the work. Bonds differ from liability insurance in that the surety company does not pay to defend the claim. Instead, the surety investigates the claim and pays it if valid. The surety then recovers from the bonded contractor the amount it paid, including its investigation costs. A bond is thus more like a letter of credit than insurance. A bond neither indemnifies the contractor nor defends the contractor. A bond instead pays the owner, while the surety issuing the bond collects or attempts to collect from the contractor. Expect bonds and their sureties to play a role in your litigation if arising out of construction work. Bonds may apply in other situations, such as to errors or misconduct by notary publics. Commercial. If your litigation involves negligence claims against a business, you may find a commercial general liability (CGL) policy playing a role. Businesses purchase CGL policies to insure the business premises against fire, flood, and other accidental loss. A CGL policy may also pay for business interruption loss from accidents and occurrences. CGL policies can also cover products liability for injuries from products that the business makes and sells, and pay slip and fall, trip and fall, and other negligence liability to business visitors. The CGL insurer will also select the defense attorney and pay for defense of the lawsuit, not just to indemnify the loss. Expect a CGL insurer to be involved in the defense and settlement of your lawsuit involving a business entity's negligence. Limits. Insurance policies have limits, and those limits can play a role in lawsuits for larger amounts approaching and exceeding those limits. An insurance limit is the maximum amount the insurer must pay in the event of an individual loss. If the loss exceeds the limit, the insured retains liability for the excess loss. When, for instance, you buy your motor vehicle insurance, you choose how high of a liability limit to buy. State laws permit motor vehicle liability limits as low as $15,000 or $25,000, although some states require higher limits such as $50,000. But you may purchase limits of $100,000, $250,000, $500,000, $1 million, or even more with an umbrella policy. If your lawsuit involves a substantial loss, Beware how insurance policy limits may affect the recovery and leave personal liability remaining after payment of the limits.